Are you a family caregiver? Are you caregiving for someone who can no longer take care of themselves? Are you overwhelmed? This is Caregiver Solutions Info with Marcia Teal. Marcia will be hosting an hour of true stories and information, tips and updates of the latest research and necessary information in the caregiving field, focusing on you, the family caregiver. An Alzheimer's disease and dementia care expert, Marcia has 15 years of hands-on experience at Arden Courts, a leader in assisted living dementia communities here in the U.S. Marcia covers everything you need to know as a family caregiver, especially if you care for a loved one with Alzheimer's disease or other related dementia or chronic illness. If you have a friend or relative that is also a family caregiver, call them now. They won't want to miss a minute. And let them know they can watch on caregiversolutions.info. And they can listen on WNN 1470 AM in South Florida or nationally on the iHeartRadio app. Now, sit back, relax, and learn from our host, Marcia Teal, as she brings information to you that may just be the caregiving solution you need.
Hi, everyone, and welcome to Caregiver Solutions Info Show. I'm so happy you could join us today. We have another wonderful program for you. If you're a caregiver and you're caring for someone who can't care for themselves, especially an older person, and especially an older person that has some form of dementia, then this show was created just for you. It's not easy being a caregiver. There's things that you need to know that you don't know because you never had to know them before. So this show brings the experts to you. And today we have another expert that is top in his field, and he's going to be talking to us today about a lot of scenarios that you probably want to take some notes on, because if this is your situation, then elder law is something that you need to learn about. So if you're joining us on local radio, AM, FM, on your radio, then hello out there. If you are watching us live stream on the internet, on your computer or your smartphone at caregiversolutions.info, welcome. Or you might be picking us up on the iHeartRadio app anywhere in the world, and I'm glad that you found it. So sit back and relax, because this show is live today from Boca Raton, Florida. And my guest is, I'm going to go ahead and just get into the show because there's so much to talk about. And he is here, anxious and willing, and I'm so happy to have him, Ryan Smoller. Hi, Ryan.
Hi, how are you? Good evening.
Thank you for being here today.
Thank you for having me.
Now, Ryan is an attorney, and he's actually the owner of Elder Law PA. And what Ryan does is that he is somebody who advocates for people, especially elderly people or seniors, and he helps them with their problems from a legal point of view, from a legal standpoint. So as an attorney, Ryan, this is going to be a great show because a lot of people don't know a lot of the legal and the legalities of things that they need to know when they become a caregiver.
Sure. I think step one, no matter what you're doing, is always information, making sure you're making informed decisions. So I'm happy to share.
Well, wonderful, because that's what we do here. We share, give lots of advice and tips and things that caregivers can use that would challenge them to be better, to do better, and to help them with their challenges in their caregiving efforts. So the first thing I want to ask you, that you do have a lot of clients. I know you're a very successful and popular attorney.
We'll go with busy.
Busy, okay. You're busy. First thing I want to ask is, how many clients come to you when they're in a crisis? There's a situation where they walk in and they say, oh my God, we don't know what to do. This is what's happened. Does that happen often?
Honestly, it would have been easier if you asked how many clients come in that are not in a crisis. Being an elder law attorney and dealing with folks late in life, it's very often that the first situation I'm faced is someone that has just entered a hospital or is just leaving a hospital or is near death. So very often we're dealing with a family who although it's a situation that I've seen before, is a brand new, scary crisis to families. So I would say that's quite often.
Well, that's too bad because it makes things harder, I would imagine, than if people had planned.
Certainly. Planning is good. However, life happens, and it doesn't always let you plan for it. So that's really why we have our doors open, so people can get comfort and answers and results in a crisis, whether they planned or had not planned.
So what happens if a crisis occurs in the middle of the night? I'm sure you don't work 24/7.
Well, so crisis for me as an elder law attorney is different than a crisis as a criminal attorney or a personal injury attorney. Most often, the first step or the most important step is making sure my client or my eventual client is always safe. So a lot of times the crisis happens after they've been admitted to a hospital or admitted to a skilled nursing facility. So we don't get that many of those overnight, we need someone there at 3 a.m. calls. We do get a lot of the, hey, it's 9 a.m., my mother or father has just been admitted to a facility. We have no idea what's going on from here. Please help us out. And that's why we offer free consultations, and we usually try to get info to them and get the situation at least sorted out as quick as possible.
Wait. Did I hear free? Free consultations?
Yes, free consultations. Again, informed decisions are better than decisions made out of haste or made out of something you heard online or something you heard at the pool. So I always say, come get the information, and because I'm giving you the information and the steps you'll need to take, hopefully that'll result in us working together in the future.
Well, that's wonderful, because when people think of attorneys and think about that specific field of elder law, they think dollar signs, and I'm sure there's a place for that. But in the beginning, I would think that a lot of people would procrastinate or postpone seeking legal advice because maybe they're afraid that it's going to cost too much, and maybe they're afraid of what they might find out.
Sure.
So by you offering this complimentary consultation, to me, it would seem that people would be a little bit less anxious and have more choices, and maybe be prompted to do what they need to do.
Certainly. I know your background has been in the care facility business, and think of it as when you took a family on a new tour. If you charged them in the cafeteria or you charged them for the time to walk around the hallways, most likely they're going to say, well, this place is nickel and diming me and I want to work with someone else. So we take that same approach. I take that same approach. Information first. If I can educate you and you walk out that door, now you at least have all the bullet points of what needs to be done. Obviously, this is my career, but at the end of the day, I've found that giving that free information up front allows clients to feel comfortable working with me towards the time to put pen to paper.
Wonderful. That's great. Thank you for that. So let's talk about what people should do when they're healthy and to avoid the crisis situation
Yes.
that we first talked about. So what types of legal assistance should a healthy person be starting to look at to avoid crisis later down the line?
Certainly. So as an elder law attorney is a term of art. There is actually a board certification, but as an elder law attorney, a lot of the time I am doing a lot of simple estate planning. So when you talk about someone coming into my office who is healthy, usually we're talking about very simple advanced directives. Advanced directives cover 3 major documents. The first is a durable power of attorney. Durable power of attorney, simple enough, allows someone who you trust to become your agent to act on your behalf as it relates to your personal property, real estate, financial accounts, and to speak on your behalf to government entities, banks, etc.
Is that only when you're incapacitated, or does it go into effect even if you're healthy, but maybe for some reason you can't be where you're supposed to be to make those decisions? How does that work?
So you make a good point, and I say the phrase very quickly, but most people may not be familiar. The phrase durable power of attorney, by definition, the first word durable, survives someone's incapacity. So a power of attorney could end at someone's capacity, whether it be a mental issue, or it would be a mental issue. But when you're stating durable, that means there's already language in there that states if I am to become incapacitated or unable to make decisions because of my mental health, this document survives that. So it's a very, very crucial document in my field, because a lot of times I am advocating or representing a client who has Alzheimer's or has dementia or memory loss or some other mental disability. And so when I'm working with their agent, I need to make sure that that power of attorney is durable. So I appreciate you bringing that point up.
Right, because if you make it when you're healthy, then being durable will kick in when you're not able to take care of whatever it is you need to take care of.
Exactly.
A step further on that note, if someone names another person as their durable power of attorney to make those decisions, and let's say down the road they have a falling out, and now the person who gave their power to this other person doesn't want this other person to have their power. They don't trust them. They don't like them.
Yes.
They just don't want anything to do with them. How does someone change to another person if it's a durable power of attorney?
Glad you asked. So all of these documents are always revocable, meaning at any time you can change them or terminate them. So practically that is a situation that comes up where it was a family member who is no longer close to my client, or it's a friend or someone else that they no longer trust. So there's a couple things. You can always create what's called a simple termination, where you're simply sending that person, putting them on notice saying, I created this document on such and such date, appointing you. As of this date, I no longer want this document to be in effect. And we would do two things if that happened. After my client signed the termination or the new power of attorney, I would do two things. One, I would send it certified mail to the person who was formally named as the agent, so they're on notice and they can never say, hey, I thought I still had complete power. So if we ever had to unwind a transaction, or if some other event occurred as a result of that person doing wrong, we have them on notice. The second, which is very important, is I would probably record that in the county where my client owned property. And I'll tell you why. Usually the biggest asset someone is looking to protect or deal with in a situation is their home or house. So by recording the power of attorney at the closing table, we can make sure that that agent who's been removed can't sneak in and sell your house out from under you, or put a mortgage on it, or take out a line of credit on it. So practically it's a difficult situation, and obviously there's wrongdoing out there, but we try to do as much as possible to make sure that that person has who they want in charge, and really it's noticed to the world by recording that document and sending it to the old agent saying, hey, you're relieved of your duties.
So you do what you can.
We do what we can
to prevent that fraud. But
sure.
In all the years that I've been working with caregivers and helping families, I have come across some difficult situations where someone who now has Alzheimer's had given their durable power of attorney to someone, and someone else came into the picture, some unscrupulous person, obviously, who had that person sign a new durable power of attorney. And it gets sticky, because you don't know, who really has the right if you don't have the termination notice. So what would you do in a case like that if you had a client, or if you were representing, a nursing home where they had two different durable power of attorneys, and maybe you didn't do the initial one, so you got called in,
Sure.
and maybe that particular attorney did not actually file the documents in the court system. So what do you do?
So it's difficult. There is no right answer, because we're dealing with real world situations. Now, the first thing I always want everyone to remember is my client is the person signing that document. My client is not the daughter on the left side of the bed. My client is not the daughter sitting on the right side of the bed arguing. My client is the one usually in the bed who is seeking help because of a crisis. So obviously the first step is speaking to that individual face-to-face if possible, or by phone if they have capacity, and really just asking them, hey, we have two different individuals who at some point of time you wanted both of them. It's time to really put, pen to paper here. We need to make a decision. Who do you trust more? And a lot of times it comes down to, well, I have two sons or daughters, and I didn't want one to be left out, so I added both of them. And I say that's all fine when it comes to presents and birthday presents, but when we're talking legal strategy, we need to make sure we have one person who can advocate for you.
Especially if the two daughters have two different minds of thinking of what they want to do with dad.
Exactly. So speaking to the client is always first and paramount. After that, if the client is not able to give me an answer, or there's some capacity issues, it's a delicate issue. I certainly want to communicate to the family that there's multiple parties here looking to get something accomplished. It's always my goal and my ethical duty to do what's in the best interest of the client. So it really is a case-by-case basis. In some cases, I may say, look, neither of you look to be fit, or your mother, my client, or father, my client, is not able to make a decision. We may need to go down the road of guardianship. Or
that's a whole nother animal.
That's a whole nother hour on the show almost. But if it's something where it isn't a trust issue and it's just two family members bickering, or two people bickering, a lot of times if I sit down as an attorney and I explain, look, let's take the emotion out of it, let's take the family dynamics out of it, let's get something done because mom or dad or who your loved one needs something done. Let's worry about the bickering after the fact. But legally, it's certainly a tough issue. I would say at least once a month we have one of those, and I probably handle it different every time depending on personalities, depending on client, and
So you're not only an attorney, you're a social worker too part of the time.
I promise you, someone on the phone called today, and I'm meeting with her. I'm meeting with her mother, and she called me trying to kind of feed me some information for Thursday, and I stopped her and I said, wait, is this a legal call or is this a therapeutic call? And she laughed and she said, this is a therapeutic call. I just wanted to get that off my chest before you talk to my mom on Thursday. And I said, I understand your concern, but ultimately, and I think you would appreciate, your mother is my client. Let me hear that from her. So yes, a lot of times I do act as just the sounding board for family who probably haven't talked to each other in years, and just because there's a crisis down in Florida, they've had to now come together. So I sort out a lot of those problems that might have been dug up from the past.
Yeah, a forced reunion and all these family dynamics. Well,
Certainly.
This is so interesting. This is really great stuff. But we're going to take a quick break, and when we come back, Ryan Smoller is going to be talking about the other documents that you need to have when you're healthy. So stay with us. We'll be right back.
Arden Courts is not just a place to live, it's a place to call home. Residential living combined with quality caregiving. This is the philosophy behind Arden Courts. Communities created exclusively for individuals with Alzheimer's disease and related dementia who would benefit from a safe and structured environment. For additional information about any of the unique services Arden Courts provides, call 888-478-2410 to locate a community nearest you. Inquire about our educational seminars, resource library, or support groups, or simply feel free to ask questions you may have about Alzheimer's and related dementias. At Arden Courts, we know, we understand, and we can help because memory care is all we do. Remember, call 888-478-2410 for additional information about any of the unique services Arden Courts provides.
Hi, I'm Michael Mole, owner of Senior.
The inability to recognize the obvious often occurs with Alzheimer's, particularly among the family members who care for them. When the time comes for you to decide that someone you love needs more help than you can give, will you be able to recognize it? Don't wait for a crisis to make the decision for you. Talk to us. We know. We understand. We can help. Arden Courts.
Story. Call into the show at 565-1470 and talk with Marcia. Now, back to Caregiver Solutions.
Welcome back to Caregiver Solutions. I'm your host, Marcia Teal. I'm so glad that you're here, and I'm so glad that my guest is here today because he's fascinating. He's an expert in his field. His name is Ryan Smoller. He's not only an attorney, but he is the owner of Elder Law PA here in South Florida. And we're talking about things that caregivers need to know from a legal point of view and a legal standpoint before a crisis happens.
Sure.
So we just finished discussing the durable power of attorney, and there were some great scenarios in there that are actual real-life cases that
All too real.
that come to the table. So, this is good information for people to try to avoid those problems. But let's talk about the other things that people should actually seek out an attorney to have when they're healthy besides a durable power of attorney.
Yes, so we covered durable power of attorney, which is personal and financial and property decisions. The second document is a healthcare surrogate, a designation of healthcare surrogate. Basically, very similar, except that this document allows you to appoint someone to make medical decisions on your behalf if you're unable to communicate or unable to make those decisions. This document would allow someone to speak to your medical professionals, your doctors on your behalf. It would allow someone to make decisions as far as medications or procedures, and it would allow someone to access your medical records so that they can make that informed decision. And that's called a designation of healthcare surrogate.
Or healthcare proxy, sometimes they call it?
No. No.
Can you explain the difference?
Yes. So a healthcare surrogate is I'm able and well right now, and I sign a piece of paper saying I want Marcia Teal to be my healthcare surrogate. A healthcare proxy is a step, we mentioned crisis, it's a step almost before crisis. If my client was already in a facility and a procedure or something needed to be done to that individual and there was no one that can make the decision, that facility can convene a board of 3 individuals, which would be called a bioethics committee. There's a Florida statute that explains this. Those 3 individuals now look to a Florida statute that explains the hierarchy of who should be appointed as somebody's healthcare proxy. So a surrogate is I decide while I'm healthy. A proxy is while I am in a care facility, the professionals at that facility appoint someone for me because it was too late for me to sign that document.
So that's when you don't have a surrogate.
Correct.
So you said 3 people in a facility, like a hospital or nursing home, assisted living. Any 3 people?
No. So they would be medical professionals. Usually it would be the administrator, probably the head of case management, and either someone, maybe the head nurse, or if it was a physician that attended that facility, or the nurse on duty. Basically, this is a decision that needs to be made in a pinch. So, you mentioned sometimes the late night crisis situation. So I always have the example in my head of, well, something went wrong in a hospital. No one was able to pick up the phone. The 3 people on duty need to have someone say, this is a life or death situation, or this requires some heavy-duty surgery, and we need to call somebody. So it's not anybody, but it is a document that a lot of times needs to be done in short order.
So these 3 people, as a committee, decide who's going to be the proxy for the client or for the person that's incapacitated. Is it true, though, that it would always go to a spouse?
You use the word decide. They're using the statute. They have to look to the statute. So the statute says that the spouse has first right of refusal, we'll call it. So they would make the decision whether the spouse is ready, willing, and able. And if the spouse is ready, willing, and able, it ends there. If the spouse cannot, then we look to other family members, I would say close people related to that individual, and finally, they're actually the last person in that pecking order is a care manager or a caretaker. So it doesn't have to be someone related, but it always would start with a spouse.
So there's a certain order they would go down and pick the best person for the job.
Exactly,
okay.
Exactly.
Good. That's good to know. I think a lot of caregivers might put off doing the legal documents of a healthcare surrogate because they assume that they'll be there to make those decisions in the hospital or in another care facility. And that's not the best way to do it, is it?
No. So a lot of my clients, whenever I'm explaining these documents, they laugh and they say, but I'm healthy. And I say, you didn't walk into an elder law attorney's office. You didn't plan your estate for you to live forever and be healthy forever. So I need you to, for a moment, as dire as it sounds, put yourself in a situation where you can't call your son or daughter and say, hey, I need you to come over. You can't, tap your spouse on the shoulder and ask her for help. This is a situation where something happened that you did not plan, and there is no one in that room with you that can help. There needs to be documentation so that a medical professional, a care provider, maybe even someone in the legal field can say, hey, this is who we're going to turn to for answers.
Well, thank you for explaining that. I think there's a lot of misconceptions between what a healthcare surrogate is versus what a healthcare proxy is. So that was a great explanation. Thank you for that. And there's one more, right, out of the three that are necessary?
Correct, and it works hand in hand with the healthcare surrogate. The third document is called a living will. Simply put, a living will is a document that you explain your end-of-life wishes, whether or not you want life-prolonging care, whether it be because of an end-stage condition that a doctor has stated you're not going to come out of, or a vegetative state where you're basically, as some of my clients would call it, a head in a bed. And by signing this document, you're usually stating that you would like to die peacefully and naturally without any type of, any type of apparatus, a breathing tube, feeding tube, anything along
being on
those
a
lines.
life-surviving machine to make you breathe, or
Exactly.
or pumped up with a lot of chemicals or anything like that, right?
Exactly.
So you decide before you need it that this is how you want to live out your days if it would come to that.
Correct. You make the decision while you are of sound mind, so that when you are not of sound mind, that same decision can be made for you. And the healthcare surrogate is usually the whistleblower. They're the one that says, hey, my loved one signed this document. We understand.
Will.
Exactly. We understand that, we love this person, but they've made a decision. So medical professional or doctor, whoever it may be, hospice, please let's allow that person to rest and spend their last days in peace.
So if a person did designate a healthcare surrogate, but they didn't complete a living will, then would it be up to the surrogate to decide what to do with that person as far as putting them on a breathing machine or a peg tube or anything else? Is it up to them then to make those decisions?
That's tricky. Remember, a medical professional, a doctor, has taken an oath to keep someone healthy and to keep someone living. That's their job. Most hospitals are probably going to make the decision on their own without consulting that healthcare surrogate, absent a living will, simply because they want to cover themselves. They don't want to keep someone alive who might now have gone through some things that they would not have gone through had they been allowed to die peacefully. And on the other end, they may decide that this has been the end of the road for the person, simply because these facilities are not always looking in the best interest of these hospitals, or whoever it may be, are looking at it objectively. They're not looking at it with emotion. So really, it's tough to comment how a hospital or how a doctor is going to handle that situation. So I would say, let's take all of the unknown out of it. Get the living will signed.
Yeah, because I can just imagine this chaotic situation where doctors, they want to try everything to help a person. They want to try every test and every available recourse to keep someone alive, because that's
which they probably
what
will.
they do. But the other person who says they're the healthcare surrogate and has the piece of paper say, no, that's not what they would want. But how do you prove it, right?
Exactly, exactly. So most likely, again, we can avoid all of this with a simple document. The doctors have a job to keep someone alive, and they will do that even if, quote unquote, alive isn't the quality of life you're used to of your loved one. So that's really where this becomes important.
Yeah, that gets really kind of tricky there, doesn't it?
Definitely, definitely. Not something you want to talk about ahead of time, but you'd rather talk about it while you're healthy than have it happen to you when you're not. And it's a bit morbid, but it's important to discuss and know.
Good point, good point. Wow, that was great. So your 3 legal documents, you heard it here, and those are very important. So I hope you wrote it down, and we're going to take a quick break, and when we come back, we're going to hear more from the expert on what you need to know about documents and elder care regarding elder law. So we will be right back.
The inability to recognize the obvious often occurs with Alzheimer's, particularly among the family members who care for them. When the time comes for you to decide that someone you love needs more help than you can give, will you be able to recognize it? Don't wait for a crisis to make the decision for you. Talk to us. We know. We understand. We can help. Arden Courts. Being unable to recognize the obvious often occurs with Alzheimer's or related dementias, even among their caregivers. When the time comes for you to decide that someone you love needs more help than you can give, will you be able to recognize it? Don't wait for a crisis to make the decision for you. Talk to Arden Courts. Memory care is all we do. We know. We understand. We can help. To learn more, visit arden-courts.com. Arden Courts follows equal housing opportunity guidelines. Somewhere at the corner of bewildered and confused is a lost mother, a father, a sibling, a grandparent. Wandering is a common symptom of Alzheimer's or related dementias and can often make those who care for a loved one feel just as lost. If you're looking for a place that's safe and secure, look to Arden Courts. Memory care is all we do. We know. We understand. We can help. To learn more, visit arden-courts.com. Arden Courts follows equal
If you
housing
have a question
opportunity
or wish
guidelines.
to share a story, call into the show at 888-565-1470 and talk with Marcia. Now, back to Caregiver Solutions.
Welcome back. I'd like to take this opportunity to thank our national sponsor, Arden Courts Memory Care Community. Arden Courts has 10 communities right here in the state of Florida and about 50 scattered throughout the United States. Arden Courts is a leader in caring for people that have memory loss because memory care is all they do. And they also care about you, the family caregiver. So they are great for resources, and today Arden Courts would like to give you a resource. This is called the 36-Hour Day book. It's an awesome book. I highly recommend it. It's in its 5th edition, so it's always being updated with current information. This book is for family caregivers to read, to be prepared. It has a lot of information on do's and don'ts and definitions of different kinds of dementia and tips on how to care for your loved one in different situations. All you have to do to get this free book is call Arden Courts on their toll-free line, tell them that you heard about the offer on the Caregiver Solutions info show, and they'll be happy to get your name and address and make sure they mail a copy right to you. So that number to call is 888-478-2410. Again, 888-478-2410. Give them a call today and get your free copy of the 36-Hour Day book. So my guest today is attorney Ryan Smoller, and we're talking about all things legal, what caregivers need to know. So we discussed the 3 important documents, and we're going to talk now about what happens if someone doesn't have the 3 important documents, which is the durable power of attorney, the healthcare surrogate, and the living will.
Correct.
So let's say people procrastinate, or like you said earlier in the show, life gets in the way and they never plan. So now they're in a situation and they have no plan, and now what happens to them? Because they can't advocate for themselves. They're in either the hospital and they're sick, or they have dementia and they can't make their own decisions because obviously they can't know what's good for them.
Sure.
By fault of reasoning is
Sure.
Compromising them. So what happens to a person like that?
So let me first start off by saying the threshold to have someone have capacity to sign these documents is not great, meaning we don't need the person to be able to recite all 17 pages of the durable power of attorney. Also, if they have a physical disability but are still mentally with it, they can always sign those documents. So elder law, one of the things that we do is we do go to facilities. We will do a mini mental evaluation, either myself or one of the attorney that my associate, and we will get these documents done on site. The reason I say this is because the next option that we talked about, the healthcare proxy, only really helps out with healthcare decisions. But if someone needs to now make financial decisions, meaning they need to pay that bill at that facility or apply for Medicaid or sell real property because that person needs money to care for the rest of their life, we need more than just that healthcare surrogate or healthcare proxy. So this is where we get into the talk about guardianship. Guardianship in Florida is basically you're asking a court to take away the rights of an individual because they no longer have the mental strength to make those decisions and hold those rights themselves. That's step one. And then step two is appointing someone in the community, whether a professional or a family member, to really step in the shoes of that incapacitated person so that they can make decisions as it relates to their property and to their medical needs.
So is it true that not having your legal documents prepared ahead of time and having to go the route of guardianship is a lot longer and a lot more expensive?
Certainly. So guardianship, just without having to get into too much, guardianship requires a petition to a court. The judge is going to appoint 2 medical professionals and a mental health professional to do independent evaluations of that individual. There is going to be an attorney appointed for that individual who might need guardianship. So we're talking legal fees, we're talking court costs, we're talking probably 2 to 3 months in a typical guardianship. And as you'd imagine, that would be a more costly and time-intensive endeavor than simply seeing us ahead of time and getting your documents executed at your own pace.
Yeah, absolutely. A good point to take care of things before you need them.
Yeah, a bit of scared straight, but sometimes in our field, that's the way to do it. A lot of times, clients don't act until they've seen it happen to a friend or family. So a lot of times my information is putting you in the situation where you don't want to be, but it's tough love. It gets a result. It makes you do something that is going to help you in the future.
So that being said, what are some of the common hurdles that you would have as a elder attorney to help people that frustrate you or that something that just you wish you could change?
So that's really the biggest hurdle. The biggest hurdle is inaction because they're healthy while they're sitting in the room. And usually what happens is when I'm finished, I've worked with a client for a number of months and they thank me up and down. I say, I wish you could stand in the corner for the next family that walks in here and explain and really shake them and say, hey, we were just where you were. Do this now. So really the first hurdle is inaction because they put it off. They say, we'll do it later. We don't have time. We want to save the money, or we don't think it's necessary now. So that's a big one. I would say the other hurdle, which we discussed a little bit, is I'm always dealing with a legal situation, whether it be planning for Medicaid, guardianship, estate or probate administration. However, there's always family dynamics with those situations. So I always tell people an elder law attorney is really just an estate planner with a lot more patience. So dealing with that family dynamics around the already difficult legal situation is certainly a hurdle.
Okay, so it would be great if people did what they were supposed to do, but we know that it's life and it doesn't happen, and therefore we need you. So thank you for doing all that you do. You mentioned Medicaid a moment ago. So Medicaid, of course, is different from Medicare, and I still get questions from people that don't understand the difference between Medicare and Medicaid.
Okay, I'll try to simplify it.
So a quick explanation of that, and then if you want to just give a couple minutes to Medicaid and what people need to know about that.
Certainly. So real quick, the easiest way to describe Medicare. Medicare is really your health insurance. It's how you're going to pay once you're over the age of 65 and taking your Social Security. Medicare is going to cover your doctors and your hospitals and possibly your prescriptions. Medicaid is everything else, meaning your activities of daily living. Who's going to help you get dressed? Who's going to help you eat? Who's going to help you bathe and get to the bathroom? That's where Medicaid, the skilled nursing services to take care of your activities of daily living, would kick in.
If you didn't have the private funds to pay for them.
If you did not have the private funds to pay for them, or you didn't have the income to cover what round-the-clock skilled nursing might cost.
So what are some of the myths about Medicaid? Because I think that it's very confusing to a lot of people, and you probably deal with this on a daily basis about what people thought Medicaid was or what it covered and what it doesn't. Can you talk a little bit about that?
Sure. The biggest myth of Medicaid is, I have too much money. And Medicaid is very specific in what's considered your asset and what's considered your income. So when someone says, oh, I can't apply, I have too much money, I say, well, do you have $10,000 in income a month? And I don't think I've gotten a yes yet to that question. And the reason I ask that is, if you were to move into a skilled nursing facility in South Florida, you're looking at probably $8,000, $9,000, $10,000, $11,000 a month at any facility. So regardless of the amount of assets you have, unless you have that $10,000 a month in income, you will be able to qualify for Medicaid, assuming you put together a plan and you're proactive about it.
So right there, that's kind of raises a lot more questions.
Well, good.
Yeah, because Medicaid, again, for people that we think that they don't have any money or they make too much money to apply. And so it's based upon income and assets,
based
correct?
on both. It's based upon both. The asset limit, just quick numbers, I hope you have a pen out, is you can't have more than $2,000 in countable assets. Now, countable assets does not take into effect your homestead and one automobile and certain investments. So a lot of people walk in my office saying, well, I have too much money, I can't apply. And then I say, well, hold on, let's break it down. Is it money that you've had invested in real estate or in some retirement accounts? Maybe it's your homestead, or maybe it's an income-producing real estate. And so that $2,000 limit, which doesn't seem very big, all of a sudden doesn't count towards a lot of the things that people have. So we can get people approved and qualified whether or not they think they can qualify. And that's really why you should come see me. We do offer free consults, so I don't ever like dealing with the people that say, I don't want to talk to you, I know I can't apply, because when there's a will, there's a way with proper strategies.
So there's something in Florida, and I want to also state to everybody out there, if you're listening not in Florida and you're hearing us and you're living in another state, that Medicaid rules and laws are different state to state.
Yeah, I should point out I'm only licensed to practice law in Florida, so any of this that you're hearing in other states, we appreciate you listening, but definitely consult an attorney licensed in your state.
There you go, a little disclaimer there. But Medicare is
Medicare is
in
federal.
every state
Medicare is
because
federal.
it's a federal program. So I wanted to make that clarification.
Sure.
But that being said, there's kind of two kinds of Medicaid for long-term living. And I want to bring this up, too, that a lot of people don't know, that there's one which I always call traditional or original Medicaid for people living in a nursing home.
Skilled nursing facility,
but
correct.
then maybe about, I don't know, was it 10 years ago or so, that Florida, the state of Florida, got a little wiser and said, gee, it doesn't cost as much for people to live in a assisted living as it does in a nursing home. Maybe we should help as a state under Medicaid people living in an assisted living for saving money for the state, because it's a lot less expensive than it is. So can you talk briefly about the different kinds? I call it the original, and then what do you call the other one?
Sure. So original Medicaid is ICP Medicaid. It's institutionalized care program Medicaid. You're in a facility. The other Medicaid covers individuals who do not need to be in a skilled nursing facility round the clock, but do need help with probably at least two of their activities of daily living. And this would be considered a home or community-based waiver. Basically, the state of Florida, as you mentioned, is doing two things. One, they're saving some money because it's obviously cheaper to keep someone at home and bring care to them or give them a stipend than to put them in a facility. And two, the threshold that I'm always looking at as an elder law attorney is how can we keep that individual, my client's quality of life with their least restrictive means and keep them at home comfortable. And that would be considered a waiver, a Medicaid waiver.
So that Medicaid waiver counts for, let's say, a memory care assisted living, too.
Correct.
Because their quality of life is more like home than it would be in a nursing home,
Correct.
especially if they didn't really need to be in a nursing home.
Correct.
So when people are wondering what to do with their elderly parent, they need to look into the options too, because it doesn't necessarily mean they have to go right into a nursing home if they could go into, an assisted living, which is not, maybe their health isn't as acute.
Certainly.
Maybe they, would have a better quality of life, a different kind of environment. And there is help out there for people that need it, that qualify for it, for assisted livings. And I just wanted to put that out there because a lot of people don't know that either.
Yes, certainly. So, everyone kind of bunches everything together into nursing home, but you go to an assisted living facility like an Arden Courts or an independent living facility, or you even stay home and get some nursing at home. The person may not need round-the-clock care. They may need just help with taking their medication and getting in and out of the bathroom every day. And for that, we don't need to put someone in a skilled nursing facility. Now, obviously, if they need that and there's multiple activities of daily living they can't complete, it's appropriate. But certainly, you should definitely know your options. Know that there's steps in between home and a nursing home where you can have a loved one stay that is capable of caring for them when the need arises. And most of those facilities will accept some form of Medicaid in Florida.
Great. So you were telling me during the commercial break about a phone call you got from a hospital regarding one of their patients
Yes.
that had been there an awfully long time.
Awfully long time.
Tell me that story.
Yeah, so we won't use any real names, right? But we're talking about a hospital who had a patient for over 18 months, as I understand
So
it.
the patient was that sick that they were in the hospital for 18 months?
The patient needed acute care. The patient needed a feeding tube at all times. The patient also had C. diff and was coming off C. diff, which is a very infectious disease. So she was in the hospital for a very long time. She had absolutely no insurance. She had absolutely no way to speak, to vocalize. She had no advocacy, no advocate for her. The hospital called me and said, hey, we found a bed at a skilled nursing facility that can care for her, but that facility will not take her if she's not on Medicaid. And they said, and she can't be on Medicaid because there's no one that can sign for her. There's no one that can help her out.
Wow, what a situation.
Yeah, it was a situation. So really what I did, and I understood that if I hung up the phone and did nothing, that woman was going to be in that same facility, same hospital for probably another 18 months. They were kind of jokingly but sadly at the same time saying that she was almost the mascot of their floor because of how long she was there. So we actually went down there. At this point, she didn't have infection anymore, and I met her personally, and we were able to communicate by notepad, and obviously she was able to understand me. And I explained to her, and I said, look, we need to get you out of here. We need to get you in a permanent residence. Because what many people don't understand is a hospital is not a permanent residence. They want you in, they want to fix you, and they want you out. The skilled nursing facilities, the assisted livings, the independent livings, these are really your residencies. So really what we did is we put a plan together. I told this woman, I'm willing to become your advocate, to become your power of attorney if you trust me. And if you trust me, I can now apply for Medicaid for you and get you out of this hospital into a more comfortable setting. So we were able to get this woman who was stuck in a hospital for 18 months. Probably within 5 weeks, we got her from the day I met her to her new residence. And it really just took some legwork, took some care, took some knowledge, but it was one of those situations where at the end, it was a smile for everybody.
Yeah, that's a real success story and a feel-good story.
Certainly.
I'm sure that made you feel really good about helping someone in such a dire situation.
Definitely.
That you had the knowledge and expertise to do that.
You don't realize how many people in this field do not have an advocate. So simply being an advocate, a voice, is helpful in its own right.
So speaking of that, and if someone wanted to have an attorney to advocate for them in all of these issues that
Yes.
we've been talking about, how does one go about choosing an attorney? Let's say they're not here in this local area where you practice,
Sure.
but they like what you say and they think maybe that's what I need to do. But how do I pick one? How do I find a Ryan Smoller where I live?
Well, at the end, I'll certainly give you my information. But if we're talking about objectively, one of the first things that I think people always have issues with is when they meet an attorney, they're scared to ask questions because they don't want to look at the attorney. They don't want the attorney to look down at them for not knowing. And I say that's the opposite. Ask every single silly question. Ask every single question that you heard that someone told you at the pool, that you read online. Ask questions. And really, there's two things you're going to find out there. One, are they knowledgeable? And two, do they have patience? I always tell my client, hey, I'm willing to talk to all 4 of your kids. I'm willing to make a call to someone out of state because they need to be filled in because they couldn't be part of the discussion. So really, I think the things you're looking for is obviously knowledge, but really the patience and the compassion to answer those questions over and over. My tagline at Elder Law is where knowledge and compassion meet, and that really goes to just that. It's basically saying, look, a lot of attorneys and a lot of people have this knowledge, but how many people are willing to explain it to an elderly individual who might need to hear it 2 or 3 times, or might need to explain it to a family member out of the state? So I would say ask questions, make that person, push that person's button, push that attorney's buttons, see how impatient they can be. And if they stay calm, that's probably the person you want helping you in a crisis situation.
Wow, that's really good advice because it's hard to pick, and you want somebody that you can relate to,
Sure.
somebody that you feel is going to be in your corner when you need them. I feel that way about you.
Oh,
so
I appreciate that.
I think that that's a good thing. So if someone is here in the South Florida area and they've heard you talking about all these issues that caregivers and others need to learn about, and they want to ask you more questions and maybe get that free consultation that we talked about, that you so generously offer, how would they do that?
Certainly. So I'll give you my local number, and you have my toll-free number. Our local number is 561-588-7512. Again, 561-588-7512. I'll leave you my email address if anyone wants that. It's rsmolar, so rsmollar at elderlawfl.com. And Marcia, do you have my toll-free number?
I do. The toll-free number to reach Elder Law PA is 888-552-7512. I'll repeat that, 888-552-7512 to reach Ryan and ask him all those questions and get an appointment and sit down and talk to him
you're
and
welcome.
ask all those questions. It's very, very important. So we got just a couple minutes left before we have to end. It goes by so fast, and I certainly appreciate everything that you've said and all the things that
my
you
pleasure.
do and to help the elders. What lasting words would you give to caregivers, to urge them to seek out someone to help them in their affairs?
So caregivers sometimes think that their role is medical only in need or companionship only. And I would say you are doing a service to whoever you're caring for if you force them to do things that are in their best interest. And what do I mean by that? A lot of you have children out there. Your kids kick and scream when you tell them that they have to shower and go to bed to go to school the next day. But you know it's in their best interest to do that. So sometimes as a caregiver, as a son or daughter, you have to tell your loved one, hey, look, I know that your health is declining. Let's be proactive. So a lot of times it's not necessarily listening to your person you're caring for, making sure it's in their best interest, but saying, hey, for your own good, we're going to plan ahead. We're going to make sure you have care. We're going to make sure you have documents. And it may create a little bit of a discord, but at the end of the day, that person's going to thank you for taking that step, for being proactive.
That is a little difficult when it's your parents.
When it's your parents.
Because your parents feel like, you're telling them what to do. and you're disrespecting them if you don't listen to what they say. And that is a very common thread that I hear from a lot of adult children. So that's something very, very difficult to do. But it's very, very important. So you just have to work through it.
You have to work through it. You have to be strong about it. And really, that's a lot of times why I do offer free consults, because they don't want to hear it from their son or daughter, but they're willing to hear it from an attorney. Hey, this is what you need to do. Your son or daughter just brought you in the room, and they're doing right by you. Now listen to someone who really is going to advocate for you professionally, and there's no disrespect. This is, you know, really what needs to be done. So it's a tough situation, but it happens, and you should push through it.
Yeah, well, wonderful. Well, thank you again for being here today, sharing all of your knowledge and expertise to all the caregivers
Appreciate you having me.
And others out there. And it was awesome information. Thank you all for being with us today, too. I'm so glad that you did. We will be back next week, same time, same place. So make it a point to join Caregiver Solutions Info and tell your family and friends to join us also. In the meantime, don't forget, give somebody a hug because they need it and so do you. So we'll see you next time. Take care.
Thanks for joining us for this week's Caregiver Solutions with Marcia Teal. Join us next week as Marcia, who has 15 years of Alzheimer's disease and dementia care experience, brings you more needed information to help with the care of your loved one. This show can be seen again on caregiversolutions.info, and questions can be left on the site, which may be used on the program to help others. See you next week for more Caregiver Solutions. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsor.